Hello. We are live, 5 p.m. Eastern Time on December the 12th of 2024. Waiting for our first question. No one in the chat yet. Just went live. Not a problem. Just went live. Gonna go pick up a package while I wait for people to gather in the channel. Just gonna go grab a package from reception. I will be right back. Hopefully, people join and ask questions. Oh, wow. We got 18 people. Oh, hi, Rebecca. My goodness, you're giving $1.49. Thank you very much. That's very generous. Thank you very much for triggering the algorithm with your donation. Thank you so much. Jamie Cello, did I see the bat symbol in the sky? Is there a bat symbol? Is there something I can help with? I just carried a heavy package up a flight of stairs here at the office. Good morning, Adriana Abernathy. Thank you again, Rebecca, for the donation. Please, no one feel the need to donate. If you want to help the algorithm, that's perfectly fine, but I do not need your money. But thank you. It's very kind. It's very appreciated. Freeway 42 says, what's the human relation? Is it the same as the EEOC? Are you referencing HR? Human resources? That is a department and many corporate entities, many employers that handles their internal human resources functions, payroll, theoretically investing EEOC complaints, EEO complaints, stuff like that. Choose Compassion says, hello, Vincent Chat. Hello, Choose Compassion, who is the channel moderator. Thank you so much, Choose Compassion. Choose Compassion has been doing amazing work helping people find videos on the channel. It's very much appreciated. YouTube user Dana says, if you have a workers' compensation case, I don't handle workers' compensation, going on, but believe it is gross negligence. Do you use workers' compensation attorney or a PL attorney? Personal injury attorney is for facial disfigurement to my nose. Dana, I'm so sorry about your nose. I hope you're okay. I hope that is fixable. I know in workers' compensation cases where you have gross negligence, my understanding in New York is that you bring both the workers' compensation case and the gross negligence case, but talk with your workers' compensation attorney about that. Certainly, that is my understanding. Adriana Abernathy says, can my employer fire me for violation of a policy that doesn't exist? If you are an at-will employee, your employer can fire you for any non-discriminatory reason. Let me be clear, non-discriminatory, non-retaliatory reason at all, or even no reason at all. They can just, like, I can just come into work hypothetically and my boss can just say, Vince, I don't like your stupid face anymore. You're fired. Completely legal termination for at-will employees. Rebecca Baldaz says, and thank you again, Rebecca, for the donation. Rebecca says, question, counsel. I have diagnosed PTSD to the documented harassment I have endured at work. I'm really sorry. I am federal and believe that there is a max I can ask for. Am I missing anything? Do you mean you're a federal employee? In which case you are correct. If you mean you're in federal court, the answer is depends where you are. In many jurisdictions, the state and local laws will provide for higher caps, and you should include those claims as well. We have YouTube user North Carolina Wesleyan Cross Country Track and Field. Do veterans get more sympathy when it comes to discrimination claims? Sometimes. Depends on the jury. Oh, Freeway 42 says, I meant the Florida Commission of Human Relations. So I can't tell you exactly what the Florida Relation to Human Commissions does, but I imagine it's a state agency that investigates claims of discrimination in Florida. Dana says, can you sue CMM, personal injury attorney? Yeah, you might be able to. So I think it's a conversation to have with your workers' compensation attorney about, if it's gross negligence, if that makes sense. Definitely. Real quick, just for the algorithm, we have 24 people in the chat, but only 6 likes. Now, Rebecca's done her part by donating. Not saying you should donate, but those likes are free. Clicking that like button is a big help to us with the algorithm. Much appreciated if you feel like doing it. If you don't, that's okay. Don't worry about it. Max Slavens. Oh, Kristen Davis says, so I filed an EEOC complaint on September the 9th of 2024. And after 2 weeks, my case was closed. I had suspicions that my assigned caseworker barely listened to my complaints, so I called around aimlessly until I got the attention of someone at the top of the chain of the commission. As of today, my right to sue has been rescinded, and thankfully my case has been reopened and will be investigated. Hey, that's amazing, Christopher. I hope that, Christopher Davis, I hope that goes really well for you. Certainly. Max Slavin says, Vince, I'm currently in law school. Amazing. And I have been deeply inspired by your channel. Oh, wow. That's incredible. I'm really glad to hear that. Once I get a law license, if I wish to join your firm or interview, what is the process? Well, generally, we take on first year and second year summer associates. We pay them pretty well. And then the ones that work out, we let continue work remotely if they want to, during their second or third year of law school, as the law allows. And then we hire from that pool into our first year associate program. So Max, by all means, apply away. Killer Balls, YouTube user Killer Balls says, hi, Vince. I just got my retaliation complaint letter from my state civil rights office. It mentions going after different types of losses, but it doesn't mention punitive damages. Does that matter now? So I don't know what state you're in, but some state laws would not provide for punitive damages and some would, right? The federal laws in a retaliation claim absolutely provide for punitive damages. But every state has a different statute, and those statutes may handle things differently. So you got to check that out. Check it out with local counsel. YouTube user Wildflower says, former employer hires many undocumented workers. This fact plays directly into my claim. Will this fact make them more likely to want to settle quickly? It might. Listen, I'm all for protecting people who are working out of status. But you bringing your claim is not you trying to hurt those people. And Incidentally, your employer is breaking federal law and might be committing some felonies, certainly something they can get fined for. So if that puts some pressure on your employer without harming those people or you, then I'm all for it, right? Christopher Davis says, until I get the attention of someone at the top of the chain of commission, as today my right to sue is, oh, I already read this. Okay. AJ So Fly 69 said, will EEOC only talk to attorney if you have one already? No, they'll still talk to you. I mean, they should only talk to an attorney. I don't really know why you want to talk to the EEOC if you hired an attorney. Like, that's kind of a classic mistake, but if they will talk to you if you want to. Rebecca Baldaws says, come on, folks, like and subscribe. Yeah, come on, folks, like and subscribe. Thank you, Rebecca. Choose Compassion says, hit the like button. It's free. Thank you. Thank you, Choose Compassion. YouTube user says, what strategies would you use in state FMLA violations, mandatory mediation, when you have your former employer dead to rights? And what damages would you ask for? Well, depends on what state you're in and what because you're specifying state FMLA violation, which means we're not talking about the federal. So you've got a statute in the state you're in that provides damages. You would calculate the damages based on that state statute. Those are your damages, and you would probably extrapolate out, and that would be your demand. But I don't know what state you're in. I know what the statute says, and I can't advise you about state law unless I go hire local counsel on a given case, and I'm not going to hire local counsel for a live stream. So here we are. Christopher Davis says, I'm a bit uneasy about everything because I had suspicions at the beginning that I wasn't being heard, and clearly I was right. Should I seek counsel even though my case is being reopened by the EEOC? I think you should always have counsel at the EEOC level. So if you and I were family, I would say, Christopher Davis, get you an attorney. No question. YouTube user Open and Shut says, looks like Wells Fargo recently assigned a defense attorney to my case. Do you think we will get a respectable settlement soon? San Francisco with $300K total comp. Maybe. I don't know the specifics on your case, but certainly if they're assigning defense counsel, that defense counsel will probably want to explore the idea of settlement with you. And if you have a great case, I would imagine that chance goes up even more. YouTube user Kate says, thank you for what you do. My pleasure. Least I could do, literally. Question. What does it mean if I have proof a certain manager tampered with performance review of a certain class? Defamation and libel. How bad for that manager? So when you say certain class, I assume you mean a certain protected class. Don't worry about the defamation and libel claims. Those claims, attorneys hate those claims. Those claims are generally not going to be that valuable. Listen, definitely talk to local counsel about it. Maybe I'm wrong. But if you are pitching employment attorneys on defamation and libel cases, you're going to have a bad day, generally speaking. What I think you're saying is the manager gave negative reviews, false, faked up negative reviews to a certain protected class. That's inherently a discrimination claim. And you should talk to employment attorneys about that discrimination claim. That sounds like a great claim. Sounds like a fantastic claim for a lot of people. So definitely consider that. I'm probably going to go for about 1 hour today. Everybody, by the way, 1 hour today. All right, sorry, just responding to something. Okay, let's go back. Where's our questions? YouTube user Bambino Dadon says, my former employer benefits from government contracts. Would it be smart to use my cause letter to stop the government contracts? Or what would you do if it was you? Yeah, I would talk to your attorney about that. If that's viable, you could certainly see if you can leverage that as a strategy. Seems, in many situations, that might be a little far-fetched. I love the way you're thinking, but like, you know, it depends what the contracts are. It depends on the situation. It depends on the severity of what happened to you. Generally speaking, I don't think there's too many government contract holders that don't have a lot of discrimination lawsuits against them, if I'm being honest. So I don't know if that's going to halt contracts, but like if it does, or if it could, there could be a way to leverage that without a doubt. Talk to your attorney about that. Tracy, what is a decent settlement offer for wrongful termination, retaliation, hostile work environment, harassment? Fired 10 days after returning from the CFRA leave and multiple written complaints submitted. Okay, Tracy, every case is a different valuation. I would hit up our damages calculation playlist on the channel. Listing your claims has nothing to do with the valuation of your case. So there's no like answer to that question. what I would do is say, like, listen, what are the chances you win the case? Hopefully you have an attorney, talk to your attorney. Like, what do we think? Like, strong case, weak case, what are we talking about here? And like, do a damages calculation with your attorney, or if you don't have an attorney, do a damages calculation using your damage calculation playlist. It's not as good as an attorney, but it's better than nothing. And that should give you an idea of what your case might be worth. And then once you know what your case might be worth at trial, if you won, you can kind of hedge for risk and say, well, listen, I think, and this is a shorthand for pro se litigants who are representing themselves. You know, if you think you're going to win 7 out of 10 times and you think your case is worth $1 million, then you might want to hedge for risk and make a demand of 700,000 because you're hedging for risk. You win 70% of the time, 7 out of 10 times. Well, then ask for 70% of what you might win. Just a hedging strategy to set your settlement, demand, not science. It's just something I suggest for pro se litigants because it's going to make things a little bit easier for them. YouTube user Wildflower says, thank you. I love my undocumented friends. Wildflower, I love that answer. YouTube user Big Bick with a B, Dallas. I read that wrong every time, Dallas. Every time I see your username, I read it wrong. And I'm like, oh Lord, am I gonna say this live? But it's Bick with a B. I just read it wrong. Hey Vince, I hope you're having a wonderful day. I am. I'm having a much better day than I deserve. I'm a pretty mediocre person, and I'm very fortunate. So it's all going to catch up with me someday. What is the advantage of filing with the EEOC and 42 USC 1981? Can I file both? Okay, so here's the deal. Your EEOC is going to let you receive a right to sue letter. Will let you file some federal statutes in federal court. You would also, if it's viable in your case, include the 1981 claim in that federal court action. You can file both, but not. You probably wouldn't. You probably wouldn't file the 1981 claim at the same time you file the EEOC unless you have some statute of limitations weirdness going on. It would have to be quite weird indeed, frankly. Probably much more likely you would file the 1981 claim in the same federal litigation action that you are including your right to sue claims in, which would have like Title VII or, the other stuff. YouTube user says, by the way, I hope I'm saying your username correct. If it's not you're welcome to correct me, and I apologize. Ask, what does it mean when the respondent has been through 5 attorneys? It means one of 2 things, maybe 3. 1, they're having a hard time paying their attorneys. Really bad sign for you, because if they can't pay the attorneys, they might not be able to pay you. 2, means the attorneys are telling them, yo, you're in trouble here. Cut this person a check, and they don't like hearing it, so they keep firing people, hoping to get different news. 3, your employer could just be a real asshole, and the attorneys are just quitting. That happens. Like, defense attorneys are pretty money hungry. I mean that with all respect. Defense attorneys of the world. I know some of you are watching. They'll take a lot of shit from their clients. I've seen it happen. I mean, I literally listened to a mediation. Like, the employer, who had defense attorneys plural, 4 of them there, was screaming at them in the other room so loud that I could hear them through the walls for hours, all day. Then you go to the bar later with those defense attorneys, and they're like, yeah, moron, paid us 30 grand to all be there just to scream at us and not take our advice. We're laughing all the way to the bank. But there's certain things the employers can do where the defense attorney is going to be like, yeah, I'm not going to put up with this. I'm going to walk. And that happens. YouTube user Dana says, after my nose injury, I was retaliated against after bringing up unsafe work conditions. Several coworkers made up false statements leading to a final write-up. Can I sue coworkers for defamation? Listen, ask local counsel. Maybe you can, but that defamation claim against coworkers, and I don't know what your coworkers have. I don't want to assume they're not all that wealthy or anything like that, but generally coworkers are not as wealthy as the employer. So defamation claims tend to suck. Suing coworkers is something you do for position or for tactical reasons, not generally for money, because it's hard to collect from individuals. What I would actually say is, hey, you've got a couple of claims you just mentioned there. You got a bit of an OSHA retaliation claim. I also hear a potential workers' compensation retaliation claim where you filed a workers' compensation case and they went after you, made false statements because you filed a workers' compensation case. So talk to your workers' compensation attorney about that retaliation case and talk to an employment attorney about that OSHA retaliation case. Those two claims sound sick, like fat money claims. The defamation claims, can't stress enough, defamation claims are losers 99 times out of 100. And like, we've taken some defamation claims and it's like special circumstances where we're like, hey, this claim is different than usual. This could work, right? Like there's very specific reasons, very deep pockets on the part of the defendant, and you can actually collect. Christopher Davis says, also, I reviewed my amended charge at the EEOC and saw minor errors, such as the spelling of the names of the people I'm accusing. Should I make my caseworker aware of that? Or is it even important at this stage? Yeah, I would get your charge correct. Amend your charge. Get it correct always. Excuse me. YouTube user Big Bick with a B. Whoa. Chat jumped ahead. Chat jumped ahead on me. Whoa. YouTube user Big Bick Dallas says, my employer has submitted their position statement, and now a few weeks later, they want to change a few things. Can they do that? Yeah, probably. The EEOC is going to let them amend. The EEOC is going to let them amend that position statement, almost certainly. YouTube user Top Op says the EEOC, the Equal Employment Opportunity Commission, is in conciliation. The employer recently disclosed their Chapter 11 bankruptcy. Should I be concerned about how this affects my ability to receive compensation? And is there anything INTD? Oh, I need to do. Okay. So good news. Chapter 11 is a workout. So the company's not going under. So there's still going to be something to collect from. Bad news. That bankruptcy is going to throw a monkey wrench in things. So what I would do is if you have an attorney, go to your attorney and be like, hey, attorney, I hired you and I need some advice about this bankruptcy. You're not a bankruptcy attorney. You should hire a bankruptcy attorney to help guide us through Chapter 11 so we know if we can settle this case right now or not. I'm not kidding. That is what we do in those situations. And like a couple of years ago, I'm not going to lie to you, this exact firm lost 7 figures in 1 calendar year to bankruptcy. Like we would put up big numbers on cases and the employer would just go bankrupt. And it's like, it was during the pandy. We don't talk about the disease that gave rise to the pandy because YouTube gets real antsy about it. But it was during that era, and like just businesses were going under right and left, and it was so hard to collect. And like we were shelling out big money on these cases to like fund these cases. And you would go through, you'd get your settlement, you get your win, whatever it is, and then the company just go bankrupt over and over a couple times, right? Adds up quick. And it can be a nightmare. So the move there is you hire a bankruptcy attorney to advise you as to what to do. They review the docket, they maybe talk to the trustee or see what the trustee's transcripts say, and you go from there. Open and Shut says, I just want to say you're the coolest. I am not. I am aggressively mediocre at best, but thank you. You're very kind. Open and Shut says, I'm seriously tempted to go to law school. You should, by all means. And when graduate and pass the New York State Bar, I'm going to apply to your firm. Please do. But like, if you're going to apply to our firm, apply while you're in law school. So you can work with us in the summers after your first and second year. That is generally the pool that we hire from, right? We have law students who work with us as summer associates and then contractors, and we hire out of that pool because they come in knowing the business, they come in knowing what we expect and how we do things. It's very advantageous for us. It can get kind of expensive training everybody, but you got to do it. YouTube user Dana says, I have a good friend named Dana. She's a really good person. My employer is a nonprofit for disability adult day center provider. The safety violations violated regulations for state-funded disability day centers. Is that false claims, OSHA? Maybe. Yeah. I would definitely talk to an attorney about the OSHA claim. There might be some state law claims to talk to a local attorney about as well. I think there's potentially some claims there. AJ SoFly69 says, when working at a former job that I have a case against, I had met life benefit. Oh, I had met life benefits through. I thought you were like, I met somebody. It was a real life benefit to me. That's not what you were saying. Say I had met life benefits to the job that would pay me for my surgery and time out of work. Surgery is from my disability that they discriminate against. Okay. Can they be forced to pay what MetLife would have paid? Depends on the case law where you are. I can see a real argument that those MetLife benefits should be included in the damages because you not getting the surgery paid for is a result of the discrimination / retaliation / termination that you experienced. So I can see the argument there. Some courts may not agree, but I certainly think you should make that argument. YouTube user Kate says, investigation is underway. Yes, protected class, solid proof. Yes, investigation is underway. Is that a federal offense? Well, it's not a federal criminal offense, but it is a claim under federal law. If people are giving negative reviews because somebody is a member of a protected class, right? That's what we call discrimination. It's a negative workplace consequence motivated by membership in a protected class. Boom, discrimination claim. Yes, that's a discrimination claim. I mean, as long as it's a federally protected class, right? Choose Compassion has posted the damage calculation playlist because Choose Compassion is our valiant channel moderator, who I appreciate a great deal. YouTube user Big Dallas says, my employer initiated my resignation email. I never quit. Can I get constructive discharge? That should be a strong constructive discharge argument, certainly. YouTube user Kate says, note the manager would probably have to get IT involved too. Good. Okay. By his grace, YouTube user By His Grace says, my complaint has finally been filed in state court, but the reasonable accommodation is going to be the RA. But the RA is going to the wrong address. So I feel like you're saying reasonable accommodation, but that wouldn't really make sense in this context. What do you mean by RA? And I've addressed this with my attorney. What happens if summons is sent to the wrong RA? Well, listen, you got to get service, right? There's no question. So, if they send it to some random address or some mistaken address, that service may not be good, and they're going to have to do it correctly. YouTube user, oh, I now see it correct. I'm so sorry. I literally thought your username was Big with a B, Bic, like Bic lighter with a B, Dallas. I now see. I now see that the username is actually Dig, as in like dig with a shovel, Bic as in Bic lighter, Dallas. Sorry. My sister's down by Dallas, having a nice time. Told me she bought a tiny home. That was a lie. She did not buy a tiny home. Why did she lie to me? Why? I was like, what am I going to bully you and make you buy a home? I just don't lie to me. What's going on? YouTube user Brian Turner. What if my HR used mediation for fact finding and uses time to cover things up? Well, listen, you don't really have to disclose too much about your case. You're not arguing your case at mediation. If you're worried that they're going to use mediation for fact finding, don't share facts in mediation. Just make your demand. That's fine. And if they're like, we're not going to give you a good settlement because you're not giving us your information, if you're really worried about it, just say, okay, then we're not going to settle today. And that's fine. Right? Okay. Whoa. Chat jumped ahead. All right. Gonna check my messages really quick. Check my messages. All right. We are halfway in. 30 minutes down, 30 to go. I funded a Christmas party tonight. Not for the firm, but like for a networking function. And like, I don't want to go. It's like a really good restaurant. The food's gonna be really good. And the people will be cool. People will be cool. But like, I am not in a Christmas party mood right now. And that party begins in 3 hours. It cost me a couple grand. I am not feeling it. I kind of just want to like call my number, like call my card number in and be like, yeah. Just let them get whatever they want. I'm not gonna be there. But that would not be professional or wise or responsible. So I will not do that. All right. It's fine where the questions are. YouTube user Christopher Davis says, I feel like my case and chances were tainted because my last caseworker from the EEOC told me she didn't feel like I had a case. So she immediately issued me a right to sue letter, but she also notified attorneys for my employer. Now this because I saw his name on, I know this because I saw his name on the respondent list of the EEOC documents. Yeah, Christopher, it doesn't really matter. The EEOC is going to end up issuing you a right to sue letter anyways. And defense counsel, if I'm being honest with you, doesn't care what the EEOC investigator thinks at all. Like, listen, I know some very talented EEOC employees. I know some really fantastic ones. But if you called me up and you were like, yo, I am convinced that my EEOC investigator can't read, I would not be shocked. Like, just being honest, EEOC workers are not all created equal. And defense counsel is not going to be like, oh, this office drone at the EEOC who doesn't do anything ever, potentially. A lot of EEOC workers just don't do anything, don't help anyone, thinks there's no case here. That's not what defense counsel is doing. Defense counsel is like, yo, I get paid somewhere between $1,100 and $2,000 an hour to know this field because I'm incredible at it. That's their take, right? So you, office drone, who can barely pay rent at the EOC, who probably didn't read anything, think this case isn't good? Well, have I got news for you? This case is a problem for me, right? Like they just don't care at all. It's not, and I'm not trying to like shit on government workers. There are many amazing government workers. There are many federal agencies that are amazing. The ATF accepted. The ATF can stop killing dogs and go, never mind. But, you know, also maybe like the Department of Education. They can probably take a walk as well. I'm kidding. But yeah, like nobody, Christopher, don't worry about it. Nobody cares what an EOC investigator thinks about a case. Ever. YouTube user Hush Money says, oh, Hush Money makes a great point. A fantastic point. YouTube user Hush Money says, I am the last person to have smashed that like button. And that was 10 minutes ago. Come on, guys. So I will say, to Hush Money's point, we have 48 concurrent viewers right now, but only 28 likes. And those likes are how the algorithm pays attention to this live stream and to our channel. So it really helps. It really, really helps if you do hit that like button, which I believe is free for you to do. YouTube user Truth Compassion says, typically when a lawyer informs the EEOC that the client is withdrawing the case and intends to commence a civil action, is that a good sign? I was relieved at first. Now it sounds downright scary. That's a very good sign. So really what you're saying is like, EEOC, give me a right to sue letter. Thank you so much for your work here, but we're going to the big show. We're going to federal court. My attorney believes in this case, and we are going on to the big show. We're going to have ourselves a federal matter, a federal trial, a litigation, right? YouTube user Annie Lynn, who was very kind to me when my cat passed. Annie, thank you again. I still remember how kind you were to me when my cat passed away. Annie Lynn says, happy holidays, counsel. Stay well and healthy with your loved ones. Thank you so much, Annie. I hope that you are well. I hope that everything's great. I hope you're having a great holiday season. Everything's going well. Jay Johnson says, if the employer misses the deadline to submit the position statement, can it help my case? They are 2 months overdue. Yeah, I mean, it can. It certainly can help your case. Carlos M says, watching your videos helped me get the right to sue, and my lawyer filed the lawsuit this December. Carlos, that's incredible. I'm so happy. I hope it helped in some way. Like, I guess you're saying it did help in some way. That makes, I always feel just ridiculous making these videos. I got to tell you, like, I don't know if any of you do this. I know that there's a viewer who streams like video games on the channel who, like, I think I follow on Instagram. But like, I don't know how many of you like talk into a camera for like hours at a time. It's a weird feeling and it feels ridiculous because there's nobody here in this office with me. It's just me talking endlessly. That's bizarre. So thank you very much, Carlos. Richard Mahan says, hi, can you please answer a question for me? Richard, I am endeavoring to answer every single question that I'm able to answer that is posted in this chat. So you have 24 minutes before this chat goes dark to get your question in, and I will get you an answer. Now, we are a little bit behind, so I don't know if we're going to get to every single one, but I feel confident that we'll try. Also, to the 10 people who like the channel in the past minute, thank you, or like the video. By his grace says, 2 key people named in my complaint. 2 key people named in my complaint that has been filed in court. What usually happens when these key people are no longer with the company? One was HR and another is my supervisor. So if they're no longer with the company, either the company will try to compensate them or subpoena them to come in and testify, or they won't be able to, in which case the company loses 2 key people and there's no potential witnesses. Now, if you need these people as witnesses, you're going to have to chase them down and subpoena them, generally speaking, or listen, you might be able to get them come in voluntarily if they don't like the employer anymore. Choose Compassion says, can a claimant be listed as a creditor if a respondent files bankruptcy? Yes. Yeah. As long as you have, listen, if you have a judgment against them or they owe you under a settlement agreement, whatever it is, if they have a debt to you, you can be listed as a claim holder in the bankruptcy estate. Certainly. It's another reason, yet another reason to get bankruptcy counsel if your employer goes bankrupt. YouTube user Miss Tiff Tigress says, hi, Vince. For depositions, is the administrative judge present? No. Also, thank you for having this YouTube platform. It's been very helpful. My pleasure. That was a very quick answer. Rebecca Baldaw says, why do so many firms not want to take federal employee EEO claims? Rebecca, because they are a ton of extra work and there's some caps, as you mentioned. Hold on one second. Sorry, I just want to blow my nose. There's a ton of extra work, and the federal employee EEO process is a giant hassle. We do take them. I had a fascinating thing. We took 2 federal employee cases recently, and my litigation teams got in a bit of a scuffle. They both wanted both the cases. So like, let me underscore that it is not always true. Like, a good case is a good case. It just, that's a reality. Like, federal employee or not, a good case is a good case. People are still going to want it. But it is hard to find law firms that will take federal employees on. We do. I've been sending people to the law office of Jonathan Bell a lot lately. He's very good. He's based, I think, in Long Island, although I think they do have, I think, like a New York City office as well. They tend to be a little bit more affordable for federal employees than we do. I think they do good work. I've known Jonathan like 15 years, I think. He's a really good dude. I think he and his wife have the firm together. I don't know his wife, but I've heard very good things about her abilities. And they have a number of attorneys there. We've litigated against them before, not like suing them, but like we've been on opposite sides of cases at some point in my history. And his associates did good work. And it was a case that got a lot of press. And I thought they handled the press well. I mean, I was just like in a closet stabbing people, like with the full court press and that. Like I was doing everything I could to be a nightmare for their client. And they were doing a really good job trying to keep me from being a nightmare. As good a job as you can do. Choose Compassion posted our deposition 101 video. Thank you, Choose Compassion. Marlena Fina says, great username. Marlena Fina says, still receiving the silent treatment and retaliation of speaking to HR by the two managers who are besties. Yeah, so silent treatment, isolation is a form of retaliation. If you spoke to HR about some form of discrimination or sexual harassment or a wage issue, that silent treatment, that isolation can be a retaliation claim. Consider speaking, if that is the case, to a local employment attorney. Checking my messages. People are wild. People say the wildest things to me. Like, I appreciate like that people feel comfortable saying wild things to me, but like, if I was a real human being with feelings, some of the stuff people say to me would be like, all right. YouTube user Mackenzie Murphy. A company has 153 million in unsecured debt and is liquidating their assets now. Big money trouble. Any strategy on taking in consideration their debt and or finding if they have insurance coverage? Thanks. Well, you can find out if they have insurance coverage, one, by who shows up as their defense counsel, because often there's going to be a scuffle over who's defending them. If they have to hire their own counsel, if the insurance company is going to hire counsel for them, there's sometimes the insurance counsel shows up with an adjuster. So if you go to mediation, you'll find out about the insurance company. In the rare situation where none of that happens, you can find out about the insurance policy and discovery. Not an issue. Let's turn to the less simple issue. Collecting from a company that is deeply in debt. 153 million in debt. Liquidating their assets. Excuse me. So a couple things we need to know. What's the yearly revenue? It's 153 million in debt, but if they've got 200 million in assets, you're fine. If it's 153 million in debt, but the revenue is 300 million a year, you're fine. Even, I would argue, if it's 153 million in debt and the company has 50 million in revenue per year, well, there's a decent chance they're going to work that out, right? They're going to get some kind of bridge loan to help them pay down over time, maybe get an interest rate, and they'll go into austerity measures. And listen, they might not be willing to cut you a settlement check as readily, but like they still could pay you if you got a judgment. Because in the scheme of things, your judgment's probably going to be, a flash in the pan compared to what they owe. So like this might still be viable. Now, if that's not the case, if it's like year-over-year revenue, 20 mil a year on average, and they owe 153 mil, which is not impossible. I've seen companies, a lot of startups do that wild stuff. A lot of tech startups, right? They'll run through like big runways of Series A, Series B, angel investor, funding rounds, and be like massively in debt due to like taking loans and stuff like that, and they just never really figure out a business model, and then they owe hypothetically 153 mil, and their revenue is like 10 mil a year. Like it can happen. If that's the case, maybe look at the founders, look at who's rich, who could be on the hook, who could you include as an individual defendant if you can, right? Like there's a lot to look at there. It's going to be a complex, detail driven calculation of how you go about this, but those are some things to look at. YouTube user Freeway42 says, even though you have evidence to all the lies by the employer, will the EEOC still say you don't have a case? So an employer lying, if it's not under oath, is not in and of itself a crime, believe it or not, right? Listen, if they're lying under oath, that's perjury. That's an issue for them. That is potentially a felony. But if they're just lying, but you're not actually describing a claim, right? Like if you go to the EEOC and you're like, my employer's really mean, they're bullies. The EEOC is going to say like, okay, so you feel your employer's a mean bully, and they did lie in this position statement 50 times. But the issue is your employer being a mean bully is worth $0. Nobody cares in almost any jurisdiction in the US, and certainly not under federal law. So yeah, they could just be like, yeah, you don't have a claim, get out of here. Employer lied a whole bunch, but like they lied about a non-claim, so it doesn't matter. If that's what's going on, that certainly could be. Now, Freeway 42, you might very well have a claim. I have no idea what you file with the EEOC. I'm sure it's a good and viable claim because you seem like a good and viable person who knows things and is savvy and all the good things, right? So don't be surprised if your claim, the EEOC just doesn't really care that much and issues your right to sue letter. They don't really think they're harming you. They think you can go on to federal court and have your day in court. That's not insane. Even if the employer is lying, you just go on to court, demonstrate the employer's lies, you can potentially win, right? That's their perspective, generally speaking. Also, can I just note that we have 43 concurrent viewers now with 43 likes. We have reached the coveted 100% like ratio, viewer to like ratio, 100%. You all are amazing. I thank you so much. Ooh, we're at 44 now, but we have 46 concurrent viewers, so we're no longer 100%. YouTube user AR American says, hey Vince, what's the discovery control plan date? Discovery control plan date. So that is a date to check in. Generally, in most jurisdictions, my understanding would be a control plan date is a date to check in to make sure that both firms, plaintiff's firm and defendant's firm, are on pace with discovery, that discovery is proceeding well, that everything is moving at the rate and deadline set by the court. It's like a control date to touch base. Whoa. Okay. Chat jumped ahead. Let me find what we got here. Oh. Okay. Trying to find where I was. Everybody's telling me not to go to the Christmas party. It's my Christmas party. I have to go. Miss Tiff Tigress says, thank you, Choose Compassion, for posting the deposition playlist. Really appreciate it. Choose Compassion is fantastic. And thank you for thanking Choose Compassion, Miss Tiff Tigress. YouTube user TO says, yo, I have a question. I finally caught you online. I just filed a motion to compel discovery of documents. The defendant is attempting to cover up their failure to produce by filing a protective order. Let's go, because I think TO goes on. When can a defendant refuse to produce documents that are clearly relevant? They don't want to give me any evidence, and I asked the court for sanctions, including terminating sanctions for any future failure to comply. Take my case on contingency, please. Okay, so real quick, I don't do intake in live chats. I don't do intake on YouTube. I don't do intake on Instagram. I know you know this. We're having a friendly chat, but this is not really for you, TO. This is for other people. I know you're being funny, you're being friendly, we're chatty, right? Like, I get it. We have an intake department. They are the people. There's filter layers between me and folks who like reach out to the firm of talented professionals who are heavily trained in how to handle case intake and everything else. That is how we handle incoming cases. If you want to contact them, they are paid and exist to help you try to get your case taken by this firm. That is how they think of your job. Like, they think their job is to, one, protect me from stalkers, but two, which has become a significant issue for me, thanks to this channel. Life is really weird now. Like, when I was telling you about the Christmas party, I had to remember to not tell you where the Christmas party was, because I've had some bad experiences, both in this office with like inadequate security, but also like other weird stuff. But I digress. What intake thinks their job is primarily is to help you get your job, get your claim, your potential claim in front of an attorney here. So they're helping you to try to like get the case kind of summarized in a nutshell in a way that they can submit it to the attorney to like get the attorney to be like, yeah, I'll take that call. So like you call the call center, they're packaging the case up kind of for the intake professionals, and they're filtering like the first wave of stuff, like people who like want to send us threats or people who want to be like stalking people, whatever it is, right? Like we've had some issues with folks wanting to ask attorneys here out and stuff like that. And the call center is really good at filtering that stuff out. Also another reason why I'm the only one from this firm who still appears on this channel. Frankly, it like weird stuff happens on the internet. So intake will get the case ready, or the call center will get the case passed to intake. Intake will like really kick the tires, really look at the case, package it up for attorneys. The attorneys review, and then you get a call or you don't. Intake, I should be clear, does have the ability to be like, not a case. We're not even going to put it in front of an attorney, but they rarely do that. Back to your discovery question. So if what you're asking for is relevant, and if the employer can produce it without like extreme hardship, then you should prevail in that motion. That's my answer. If there's something else going on, listen, there's specific issues that could come up, but like that should be the context. All right, now I have to go back because I jumped ahead for T.O.'s question. YouTube user Hush Money, I'm sorry I skipped your question. I'm so sorry. Can you ask it again? I did not. I thought I answered your question, but I will try again. I do laugh too much. I am a fool and a jester at my core. I'm not a good jester. I'm not saying I'm funny. I think I'm funny. YouTube user By His Grace asks, can the defendant ask that the complaint be dismissed in state court because the summons was sent to the wrong RA, registered agent? Yeah. So you have to get service correct. You just have to get service correct. So like if you send it to a registered agent that is not correct, then you would need to send it to the correct registered agent or like handle service correctly. That would be required because they can't like be expected to defend a case if they're not receiving service about it. Okay, YouTube user. Wow, this is a great username. YouTube user, whose name is in fact user, says, I was fired after requesting Family Medical Leave Act time for a sick parent. My parent developed my parent developed cancer over the next 4 months. I'm sorry. I was caretaker and it was infeasibly looking for a job. Can I get economic damages for those 4 months? Yeah, I think that's reasonable. They fired you, so I think you can certainly demand damages for that period of time. Economic damages, emotional damages, the works. Marlene Athena says, go home, LOL. Yeah, I should go home. I can't. Mackenzie Murphy says, stay home, LOL, smiley face. Yeah, I got to go to this party. I don't know. And like, I know at this party, like, it's like a prepaid party. So I've already paid for the meal for all these people. And then like, I like pre-bought like 8 bottles of wine, I think. And I know these people are going to be like, I don't want wine. I want cocktails. And this place, the cocktails are like $30. And I'm just going to be sitting there staring at these 8 bottles of wine that I paid for in advance, being like, they all want cocktails. I don't want to be cheap about it, but like, I just know I'm going to feel ridiculous. All right. YouTube user Superficial Looks says, is it possible to create your own demand pro se? Sure. Well, the EEOC continues to investigate side eye and deep sigh. Yes, you absolutely can. Superficial Looks, I recommend a damage calculation playlist. That is a great way to help you value your case. And once you value your case, you can set a demand. YouTube user Brian Davis. I filed a claim with the EEOC for discrimination or retaliation, and the case is currently in investigation. I am still working at the job, but I've been experiencing further hardships. Can I file again for another charge of retaliation? Yes. So you can ask the EEOC if you can amend to end the retaliation in, or if you don't want to do that, or if they won't let you do that, you can just file a new case for retaliation, for the new events of retaliation. YouTube user Chris Young says, good help is hard to find. Believe it. I do, Chris. I believe it. I listen. It's dark out there. It is hard to be a plaintiff in this industry. It's not easy. I know that. That's part of what we do the channel for. It sucks. I mean, the original purpose of this channel was to help plaintiffs, and then it became like a whole other thing where like it was valuable to the firm. But yeah, I'm sorry, Chris. One second. Sorry about that. A little congested. Okay. Marshall Leonard says, what percentage do third-party investigations side with the accuser, considering that the employer pays for third party? Marshall Leonard, I don't know the exact percentage, but I would say way, way more often than they should. You were absolutely correct. Third-party investigation companies are aware of who is paying the bill. No question. YouTube user Brian Davis says, I just subscribed and liked. Marlene Athena says, I hit the like button. Both of you, thank you so much. We are now at 50 concurrent viewers with 52 likes, which is amazing. We're at more than 100% likes because people come and go. Okay. YouTube user pre-citrus. Is that like before you eat an orange? Before issuing a right to sue letter, does the EEOC notify an employer if there is a finding of discrimination? My case has been at the investigation for over a year. Thanks, Vince. Pre-citrus, my understanding is that the employer finds out when the right to sue letter is issued at the same time that the plaintiff does. Although I'll be frank with you, EEOC investigators are like the poster children for like loose lip ships. Like routinely, EEOC investigators will be like, and also a lot of state agency investigators will like call me up and be like, hey, I'm going to give you this finding. So like, you might want to do something about that. It's going to be good for you. Or like, hey, I know your client's got like a $250,000 offer on the table, and not for nothing, I'm about to give like a somewhat negative right to sue letter for you. So if you want to go ahead and take that settlement right now, might be a good idea. And I'm just like, investigator, no one cares. Like, thank you for telling me. I appreciate you spilling the tea and helping me out, but like, no one cares. Like, we're not going to like take a settlement because the EEOC is going to issue a right to sue letter. Like, that's just not how this works. Marlena Fina says, why won't a lot of lawyers take a case against the state? Marlena, it's because states are not playing with their own money, right? Like often corporations are worried about losing money. A state agency, it's not their money. It's your money. It's a taxpayer money. So like, they just don't really care that much. And what do you like? Great examples like the MTA in New York, Mass Transit Authority, one of the most hated organizations. Oh, you got a case against us? And the state's going to give us money no matter what. And the federal government's going to give us money no matter what. So we don't care. So instead of getting a settlement, you have to like litigate all the way through. Like often state agency cases, municipality cases, municipalities are a little different because local politics get real quick. But like state agencies, often you have to litigate further, put more pressure on. It is exponentially more work. We do take those cases, but it is exponentially more further, put more pressure on. It is exponentially more work. We do take those cases, but it is exponentially more work. We just understand that. We think it's worth it. We also take them because they have a slightly higher chance of going to trial. And we like it when cases go to trial. Double M, YouTube user Double M says, what happens if you obtained an attorney that handles the EEOC, does not litigate? What should the client do? Hire an attorney who litigates. And make sure that the attorney that you hired to handle the EEOC waives her or his contingent percentage because they are not litigating the case, so they should not get their percentage, in my opinion. YouTube user Jay Johnson says, thank you for answering my question. My lawyer is too busy to respond to my emails. LOL. Jay Johnson, that is a problem. That lawyer works for you and could make a lot of money off you, so they should be answering your questions. YouTube user Jamel Thomas says, hi, I'm a 100% rated disabled veteran. Thank you for your service. I was let go. And also, if it annoys you to say thank you, that I said thank you for your service, I get that too. I'm sorry. Different people, a lot of different people have different thoughts on that. There's definitely veterans who are like, I like being thanked for my service. There's our farm manager would like punch me in the face if I thanked him for his service. So like, I get it. Hi, I'm 100% rated disabled veteran. I was let go 3 weeks. I was let go on 3 weeks before my probationary period because I was overworked and it affected my disability. Do I have a case? Well, it depends. Did you let them know about your disability and ask for a reasonable accommodation? If you did, and if you think that's why they terminated you, then yes, you have a claim. You may also have a claim if you had a medical condition. You might have a workers' comp claim. If you have some injury exacerbated or made worse by what was going on at work, or if they violated any kind of other laws, right? But yeah. Digital Alex says, hi, case against NYC, New York City. Will I still need to chase them down if they retired? Potentially, yeah, if you need them as witnesses. YouTube user Motoni, either Motney or No Tony says, how long does breach of contract wrongful termination settlement negotiations take? Time frame. Okay, so breach of contract is a little bit different, but I can give you an idea of like what a wrongful termination. If by wrongful termination you mean like workplace discrimination or workplace sexual harassment, if you mean something like they breached a contract, like you had a guarantee of employment in your contract or something like that, those can be incredibly fast or incredibly long because everybody pretty much knows who's going to win. There's not as much variance in those cases. So like 4 weeks or 4 years is the answer. But if you're talking about like a discrimination case, the wrongful termination, I think about 15% of our caseload resolves in the first 3 months. About 80% resolves between 3 months and 9 months. And then that last 5% goes from about 9 months to 4 years. And the 4 years is like an outlier, but like we did have a case go for 4 years, I think. Okay, we are a little bit over. YouTube user Zay Madden says, hey, Vince, do employers receive a notification of your initial EEOC complaint, not the notice of just not the charge of discrimination? I don't believe so, Zay Madden. I don't believe there's any, if you don't actually file a charge of discrimination, I don't believe the employer gets anything. I guess there's certain scenarios where they might get something, but like I almost never. Brian Davis says, what can happen if you file a second charge of retaliation while still working at the company? If I feel like I've been retaliated against, what would I need to prove to successfully file the second charge? You would need to prove that you experienced a negative workplace consequence after you engage in protected activity. That's essentially what you need to prove for a retaliation case. What could happen? Well, either they might keep retaliating or they might get scared and stop retaliating. Things can get worse or things can get better. Not much of an answer, but accurate. YouTube user Tio says, nobody will take my case. I'm assuming it's because I'm seeking representation based on contingency. Tio, there are still, and also when you say Tio, are we talking about Terrell Owens of previously the Buffalo Bills fame? But Tio, so listen, there are still firms that take cases on pure contingency. If you know, it depends on where you are. If you're in New York City, like right off the bat, we have a collaboration going live, I think on Monday with attorney Marjorie Mesidor. I don't know. I think she might be on pure contingency. She's fabulous. She's a great attorney. I'm not allowed to recommend attorneys. That was not me vouching for an attorney because our insurance company will let me. I just think that Marjorie Mesidor is an incredible person. And I think it's possible that I sent my sister her when my sister had a case. Maybe. But I can't recommend her. I'm not allowed. But listen to you. I don't know why people aren't taking your case. There's always the possibility, one, you're doing a bad job pitching it. There's a possibility you don't have a case and you just think you do. Not saying that's with Kate. I'm just saying that's a possibility. We see lots of those. See many, like 20 of those a day, potentially. Could just be that the firms are filled up right now, which I don't think is true, but it's possible. A lot of employment, like plaintiff side firms, have gone out of business in New York recently. Like I think like 9 plaintiff side firms of like some decent size in New York went out of business this year, which is wild to me. Like I'm sitting here like, oh my God, we just need to hire more attorneys. Like I got to find good attorneys to hire, and other firms are going out of business. I don't know what's happening. But I don't know why people aren't taking your case. The easiest answer is you might not be doing the best job pitching your case, and like I get that because it's not your job to know how to do that. So one thing you consider doing is hitting our like find an attorney playlist, because that's going to tell you like there's some videos in there on like how to like pitch your case and like make an elevator pitch for your case and like make it more appealing to attorneys, get them to listen to you. A lot of good information there. Might help. M. Romero says, in a video, you said your firm doesn't include wrongful termination or breach of contract claims. Why not? Have a good day. So M. Romero, wrongful termination in most of the country is not a claim for most people. If you are an at-will employee in most of the country, there is no such thing as a wrongful termination claim. Now, if you are terminated due to discrimination or terminated as a result of sexual harassment or terminated as some form of retaliation, those are all claims, right? If you're terminated for complaining about safety issues, potential claim. If you're terminated about talking about paid wages, potential claim. Like all claims, right? But just wrongful termination, saying like, I was fired and I shouldn't have been. Well, the reality of the situation is that if you're an at-will employee in almost anywhere in this country, but almost anywhere, you can be fired for any non-discriminatory reason, any non-discriminatory, non-retaliatory reason, or no reason at all. So wrongful termination claims generally do not exist. If you have a contract that says you can only be terminated for a cause, yes, certainly we would include the breach of contract claims there. Most employees do not work subject to a contract in the United States. Most employees are not guaranteed employment in a contract in the United States. That is incredibly rare in the United States. Certainly, we litigate those cases when they do come up, and we certainly include those claims, but it's incredibly rare. YouTube user Hush Money says, here's my question again. Is it a breach of code of ethics for an attorney to take on a discrimination case on an hourly fee they don't believe they can win? I believe the ethical standard for attorneys is they can take a case they believe might not win, but they can't take a frivolous case. So like if they believe the case should win, if they believe there are valid legal arguments, if they believe the claim is itself valid, but they're worried about the ability to win it, I don't think that is an ethical violation so long as they tell the client that, right? There are definitely cases that we pass on that we're like, hey, listen, we think you have a claim, but like we're worried about our ability to win it. We're not going to take on that risk. That some attorney will take on an hourly basis and make, I don't know, tens of thousands of dollars litigating. And like, as long as that attorney told the client, hey, I share, Vince's concerns. I think this is a high risk case. I think you have like a low chance of success here. I think you're right. I think this is a legit claim. I just don't know if we are going to be able to win at trial because we lack some evidence or whatever it is, whatever adds risk to the case, right? That to me is not frivolous, or that to me is not an ethical violation because the case is not frivolous. And you had a frank conversation with the client being like, hey, I have a lot of concerns. I don't want to mislead you here. I think you're like, if it was me, I wouldn't spend my money on this because this is a high risk case. I get why you might want to. You might want to fight for the principal. You might want to hold these people accountable. There's a lot. You might want to spend some money on a long shot, right? You think you got a 10% chance of victory, and if you win, the case is worth, I don't know, 10 mil. Okay, some people might think that's pretty good odds, considering what the upside is. I don't know. So it's not the attorney's job to tell clients they can't pay them, although I certainly don't think it's the right thing for us to do. It's not something we want to spend our time on. Like we have to really believe in a case. Even our hourly cases, we have to believe in to take them. But I don't look at an attorney who would take that case in that scenario and be like, you're disgusting. they're giving that person their shot at litigation, right? YouTube user Choose Compassion says, we need a story time on the random things people say to you. You wouldn't believe them. You would think I was lying. I'm pretty sure. I'm pretty sure. Okay. We've been going for an hour and 10 minutes now. Oh boy, there's a lot of questions left. I'm so sorry, everybody. A. Watkins says, if the cases were 10 mil, then are they going to reduce it down to the $300,000 cap? LOL. Watkins, A. Watkins, remember that although there are federal caps, many state and local laws are not subject to such caps. And so a case can, in fact, be worth 10 mil. It is rare. I agree with you. Okay. I'm going to call it here, everybody. I'm sorry about the questions I didn't get to. I'm so sorry. Okay. Yeah. I got to stop. I got to go. Jacoby, what's your question? Real quick. Post it again. Last question, Jacoby. Last question. And I know I skipped people. Jacoby just said something here. Okay, Jacoby, ask it. I get it. You only got a few days left. Posty post. Posty post. We're counting down. Jacoby, I got to go. Jim is calling me before Christmas party. In favor of what? Okay. I'm going to go. Jacoby, post your question on a video as a comment, and I will try to get it to in the queue. Everybody whose question I didn't get to, I'm so sorry. I'm so sorry. Yeah, post your questions, or I will do another live next week. Take care, everybody. Wish you well. Have a great weekend. Rebecca, thank you again for the donation. All right. I wish you all well. Tomorrow, I will be headed to the farm for a long time. Very excited about that. Take care. Happy holidays, everybody. Bye. Oh, like, subscribe, comment down below. Share our channel so it can grow.